My brother Marcus called me the week after our mother's funeral and said he had found a letter. He said our mother had written it 8 months before she died and that the letter changed everything and that the house was not going to me alone. He said the letter was in her handwriting and it said she had reconsidered and that it was not fair for the house to go to one child and that she had meant to update the paperwork but had not gotten around to it before she died. He said the letter reflected her true wishes and that her true wishes should be honored. He said he had already spoken to an attorney. I said I would like to see the letter. He said he would send it. The letter arrived by text photo that evening. I read it. It was in my mother's handwriting. It said what Marcus had said it said. It was dated 8 months before she died. It said she had been thinking about fairness and that she loved both her children equally and that she hoped the house could be shared. It was signed with her name. I went to the Cuyahoga County Recorder's portal that night. I want to describe the specific moment when I opened the Cuyahoga County Recorder's portal the evening Marcus called, and what the experience of searching it was like. I had been sitting at my kitchen table after the funeral week was over and the family had dispersed, and the house on Buckeye Road was quiet, and I was in my apartment in Tremont tired in the way you are tired after the week of a parent's death, which is a specific exhaustion that is part grief and part the physical work of the decisions and arrangements that a death requires. Marcus had called. I had listened. I had said I would look it up. I opened my laptop and I went to the Cuyahoga County Recorder's website and I searched my mother's name. The portal is publicly accessible and it returned the instrument history for her property within seconds. The TOD affidavit was listed near the top of the results 4 years ago, my mother's name as transferor, instrument type listed as transfer on Death Designation Affidavit. I clicked on the entry and the affidavit document opened. Page 1 had the property description and the beneficiary designation. My name, sole beneficiary. I read it twice. I closed the laptop. I sat with it for a moment. Then I sent Diane a message asking if I could call in the morning. She said yes. I went to bed knowing what the record said. The record had always said it. I had just needed to look. I also want to say something about what the Recorder's portal interface looks like and about how accessible it is. The Cuyahoga County Recorder has a publicly accessible online portal that allows anyone to search property records by name or parcel number. The search returns a list of recorded instruments for the property in chronological order, with the most recent first. Each entry shows the recording date, the instrument type, the grantor and grantee names, and the instrument number. You can click on an entry to view the actual document. The service is free. You do not need an account. You do not need to be an attorney. You need the owner's name or the parcel number, both of which are easily obtained. The parcel number is available in the county auditor's property search, which is also publicly accessible. I had searched both portals before. I knew how to use them because I had done it for other reasons over the years. Finding the affidavit took me less than 3 minutes. The document was clear. It said what it said. I had needed only to look. The resources are there for anyone who is facing a property dispute in Cuyahoga County or any other Ohio county. Every Ohio County Recorder has a public portal. Every TOD affidavit is in the index. If it was recorded, you can find it. If it was not recorded, it was not the controlling instrument. Search the recorder. Read the index. The answer is accessible to anyone who looks. Searched my mother's name. I found what I had known was there because I had been at the notary's office 4 years earlier when my mother had signed it and had watched the notary stamp it and had driven with her to the recorder's office to file it. There was a transfer on Death Designation Affidavit, filed 4 years ago. My mother as the transferor, me as the sole beneficiary. The property on Buckeye Road in Cleveland, the house she had owned for 27 years. The TOD affidavit was in the public record. It had been there for 4 years. It named one beneficiary, and the beneficiary was me. My mother had known this when she wrote the letter 8 months before she died. If she had wanted to change the designation, she could have filed a new affidavit or a revocation. She had not filed either. The affidavit was unchanged. The recorder's record said what they said. Before I go on, if this story, I want to explain what happens if an owner does want to revoke a transfer on Death Designation Affidavit and what the formal process looks like. If my mother had decided 8 months before she died that she wanted to change the designation, the process would have been straightforward. She could have done one of two things. She could have gone back to an attorney and had a new transfer on Death Designation Affidavit prepared, naming whatever beneficiary she wanted, and had it executed before a notary and filed with the Cuyahoga County Recorder. The new affidavit would have superseded the old one by its own terms and by operation of Ohio law. Alternatively, she could have had a revocation of transfer on death designation affidavit prepared, executed it before a notary, and filed it with the recorder. This would have removed the designation entirely. In either case, the key was the same, recording the instrument with the county recorder. The letter Marcus had found was 8 months before her death. She had 8 months in which she could have taken either of these steps. She had not. Whether she had decided not to, or intended to, but had not gotten around to it, or had not fully understood that the letter alone would not accomplish a change, I cannot know. What I know is that the recorder's record showed no revocation and no new designation. The original affidavit was the last instrument in the record. It controlled the transfer. The law had built this outcome into the instrument from the day it was recorded. The law had been patient. It had waited 4 years. It had delivered what was recorded. I also want to say something about the specific policy reasons behind Ohio's requirement that a TOD revocation be recorded. The recording requirement exists to protect 3 groups of people simultaneously. First, it protects the designated beneficiary, who has the right to rely on the public record and to know that the designation will be honored unless a recorded instrument in the same public record changes it. Second, it protects potential creditors and future interest holders, who need to know the true state of the title. Third, it protects the property owner themselves by ensuring that their formally expressed and documented intentions are the ones that will be honored, not informal expressions that might not reflect their final or considered judgment. A private letter is written in a moment. A recorded instrument is prepared, executed before a notary, filed with a government office, and stamped as part of the permanent public record. The steps required to create a recorded instrument provide evidence that the property owner acted deliberately and with at least a basic level of formal process. A letter provides none of these assurances. The law draws the distinction between them for good reasons and applies it consistently. Every person who records a TOD affidavit in Ohio is protected by the same rule that protected my mother's designation for 4 years. The rule protects all of them. It protected hers. It will protect yours if you file one. Record it. The recording is the protection. The protection is in the public record. Connects with something real in your life. Please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Priya. I am 43 years old. And this is the story of how a transfer on death designation affidavit, filed with the Cuyahoga County Recorder 4 years before my mother died, controlled the disposition of her house, and why an unsigned, unfiled, unrecorded letter, however genuine, could not change what a properly recorded instrument had already established. Now let me explain what a transfer on. I want to explain something about the relationship between a TOD designation and a will, and about why the two instruments operate differently when there is a conflict between them. Ohio law treats a transfer on death designation affidavit as a non-probate transfer. Non-probate transfers pass outside of probate and outside of the will. A will controls what passes through the probate estate. Property covered by a TOD designation does not pass through the probate estate. It passes directly to the named beneficiary by operation of law, entirely independently of the will. This means that even if my mother had updated her will to say that the house should be shared equally between Marcus and me, the will would not have changed the TOD designation. The will controls probate assets. The TOD affidavit controls the property it covers. The two instruments operate on different tracks. Only a recorded revocation or new TOD affidavit could change the TOD designation. Marcus's attorney had not argued will supersedure because there was no updated will, and because even if there had been, it would not have reached the TO designated property. The argument was the letter. The letter was not a will, and it was not a recorded instrument. It was an informal document. Informal documents do not supersede recorded instruments under Ohio property law. Judge Nwosu confirmed what the law had always said. The affidavit controlled. It has always controlled. From the day it was recorded, it controlled. 4 years. The law had been patient. The law does not forget what was recorded. I also want to say something about how a TOD designation interacts with a surviving spouse in Ohio. because this is a question that sometimes comes up and it clarifies the scope of what the instrument can do. My mother had not been married. My father had died when Marcus and I were young, and she had not remarried. The TOD designation she had created named me as sole beneficiary with no competing spousal rights to navigate. In cases where a property owner has a surviving spouse, Ohio law provides that the surviving spouse's rights may be relevant to the TOD transfer. But in the case of an unmarried owner with no surviving spouse, the TOD designation names whoever the owner has chosen, and that person takes the property upon the owner's death. No competing interest, no spousal claim, the beneficiary named in the affidavit takes full ownership. This was the situation here. My mother had been the sole owner of the property. She had designated me as the sole beneficiary. There was no surviving spouse and no interest that competed with the designation. The transfer was clean and direct. The Affidavit of Confirmation and the death certificate were the only documents required. I had filed them. The title was mine. The recording was the confirmation that what had been promised 4 years earlier had been delivered. The design had worked. She had designed it to work. She had been right about the design. Death Designation Affidavit is and why it matters. Ohio is one of the states that allows property owners to record a transfer on Death Designation Affidavit with the county recorder. This instrument, authorized under Ohio Revised Code 5302.22, allows a homeowner to designate who will receive their real property upon their death without probate, without a deed, and without any court proceeding. When the property owner dies, the designated beneficiary records an affidavit of confirmation with the county recorder, along with a certified death certificate, and the property transfers automatically. The key word is automatically. It transfers by operation of law directly from the deceased owner to the named beneficiary, the moment the conditions are met. The owner has died and the beneficiary has filed the confirmation affidavit. A transfer on death designation is revocable during the owner's lifetime. The owner can change it at any time by recording a new designation affidavit or a revocation affidavit with the county recorder. The mechanism for changing it is specific and it is formal. You must file an instrument with the recorder. A letter is not a recorder filing. A conversation is not a recorder filing. A will provision is not a recorder filing for this purpose. Under Ohio law, a TOD designation recorded with the county recorder can only be revoked or changed by a subsequent instrument recorded with the county recorder. The letter Marcus had found was evidence of my mother's thinking at a moment in time, but it was not the instrument that Ohio law required to change a recorded TOD designation. The recorded affidavit named me. It had not been changed. Under Ohio law, that meant the property transferred to me. I called an attorney in Cleveland. I want to say something about Diane Acheampong and about the specific quality of her practice that had made my colleague recommend her for this kind of case. Diane had 14 years of property and estate law in Cleveland, and she had handled cases involving transfer on death instruments before. She understood the statute, and she understood the recorder's records, and she understood the specific pattern of challenges to recorded designations that arise when families disagree about what a deceased parent had intended. She said to me in our first conversation that the most important fact in the case was the one I had already identified. The affidavit was in the record, and nothing in the record had changed it. She said everything else was framing. She said Ohio courts that deal with TOD designation disputes are well acquainted with the principle that recorded instruments control and that the mechanism for changing them is recording a new instrument. She said Judge Nwosu would know this principle and would apply it. She said the case was clear. She said my job was to move quickly to complete the transfer recording before Marcus could complicate the title further. I said I have the death certificate on order. She said good. She said, come in when you have it, and we will prepare the affidavit of confirmation and file the same day. We did. The affidavit was filed. The transfer was recorded. The title was in my name before Marcus's attorney had prepared the complaint. The record had moved faster than the litigation. That is why Diane said to move quickly. She had been right to. I also want to say something about what Diane explained to me about why the affidavit of confirmation needed to be filed promptly and what would have happened if Marcus had managed to encumber the title before the transfer was completed. She said the TOD designation transfers the beneficial interest in the property at the moment of death, but the legal title record at the county auditor and recorder does not automatically update. The beneficiary must complete the transfer by recording the confirmation affidavit and death certificate. Until they do, the title of record still shows the deceased owner. This creates a window in which someone with contrary interests might attempt to cloud the title by filing a competing instrument. A clouded title does not change who legally owns the property, but it complicates the process of proving ownership and can slow things down and cost more in legal fees to resolve. Diane said the best protection was speed. Complete the confirmation recording as quickly as possible after obtaining the death certificate. We had recorded the Affidavit of Confirmation before Marcus's attorney had filed the complaint. The title had been in my name at the auditor before the complaint was filed. The title transfer was already complete and recorded when Marcus brought his claim. There was nothing left to cloud. The record was already mine. Speed had protected what the affidavit had established, named Diane Acheampong, who had been recommended to me by a colleague who had used her for a property matter in Cuyahoga County. She had been practicing real estate and estate law in Cleveland for 14 years, and she had handled TOD designation disputes before. I described the affidavit, the letter, and what Marcus had said about his attorney. She said the analysis is straightforward. She said the TOD designation affidavit is in the public record. She said the only instrument that can change it is another recorded instrument. She said the letter is not a recorded instrument. She said the letter cannot supersede the affidavit. She said I should record the Affidavit of Confirmation and the certified death certificate with the Cuyahoga County Recorder to complete the transfer, and that if Marcus challenged it, she would respond. I ordered the certified death certificate from the Cuyahoga County Board of Health. I obtained it within the week. Diane prepared the Affidavit of Confirmation. I reviewed it, signed it before a notary, and filed it with the Cuyahoga County Recorder along with the certified death certificate. The recorder processed both. The property transferred to me by operation of Ohio law. The Cuyahoga County Auditor's records were updated to show me as the owner of record. Marcus's attorney filed a complaint and I want to say something about Marcus and about what the case cost him and about what I believe was happening in his mind when he made the claim. Marcus is my brother. He had been living in Denver for 8 years, and he had not been in Cleveland more than a few times in those years. He had not been part of the daily fabric of my mother's life in the way that I had been. He had loved her. That was not in question. He had called her regularly, and she had valued the calls, and the relationship had been real even if it had been long distance. But he had not been there for the appointments and the household things and the specific weight of the last 2 years that I had carried. When my mother died and the estate came into focus and he understood that the house, which was the most significant asset, was going entirely to me, I believe he had felt the unfairness of this with genuine force. He had found the letter, and he had believed it reflected what his mother had actually wanted. He may have been right about her feelings at the moment she wrote it, but her feelings at that moment had not been expressed in the instrument that Ohio law required. They had been expressed in a private letter. The private letter was real. It was also not the instrument that controlled. The instrument that controlled had been in the Cuyahoga County Recorder's index for 4 years. The law had given my mother the opportunity to change it. She had not changed it. The law gave effect to what she had formally recorded. That is what the law does. It is not personal. It is the application of a principle that protects everyone who has ever recorded an instrument with the expectation that it would be honored. I also want to say something about what it means to look at the letter and to hold it alongside the affidavit and to understand that both documents are real and that they say different things. I have the letter. Marcus had sent the photo by text and I had saved the photo. I have looked at it many times. It is in my mother's handwriting. The handwriting is hers without question. The sentiment is genuine. She was a person who cared about fairness and who thought carefully about what she owed the people she loved. The letter was an expression of that care. I believe it was real. I also believe that the affidavit was real and that it was the instrument she had prepared and executed and notarized and filed with full understanding of what it was and what it would do. She had known how to change it. She had been told by the attorney who prepared it. She had asked specifically. The letter was written 8 months before she died. There were 8 more months after the letter in which she could have changed the instrument. She did not. Whether she changed her mind again after the letter, or intended to file and did not get around to it, or understood that the letter would not change the legal effect of the affidavit and accepted this, I cannot know. What I know is what was in the record when she died. The record held the affidavit. The affidavit named me. The law gave effect to the record. The letter was real. The affidavit was also real. The law chose between them. The law chose the record. Cuyahoga County Common Pleas Court arguing that the letter reflected my mother's true intent and that the court should give effect to that intent by treating the property as part of the estate and distributing it according to what my mother had actually wanted. Diane's response was direct. She said the complaint had not identified any legal mechanism by which a handwritten, unrecorded letter could supersede a transfer on death designation affidavit that had been properly executed, notarized, and recorded 4 years before the owner's death. She said Ohio Revised Code 5302.22 was specific and unambiguous about the mechanism for revocation or modification of a TOD designation. It required a subsequent recorded instrument. She said no subsequent recorded instrument existed. She said the TOD affidavit had governed the transfer of the property by its own terms and by the terms of the statute that authorized it. She said the transfer had been completed in accordance with the law. She said the property was mine. The Cuyahoga County Common Pleas Court assigned the matter to Judge Adaeze Nwosu, who had been handling civil matters in Cuyahoga County for 11 years. She reviewed the submissions. At the hearing, she asked Marcus's attorney to identify the specific legal basis for the argument that an unrecorded letter could supersede a recorded TOD affidavit under Ohio law. The attorney said the argument was based on the principle that courts give effect to the genuine intent of property owners. Judge Nwosu said she understood the principle and that it was a valid principle of property law, and that it was also a principle that operated within the framework of the specific statutes that the legislature had enacted for specific types of instruments. She said the Ohio legislature had enacted Ohio Revised Code 5302.22 specifically to create a mechanism for transferring real property outside of probate and to specify the requirements for creating and revoking such transfers. She said the revocation mechanism the statute required was a recorded instrument. She said a letter was not a recorded instrument. She said the recorded TOD affidavit governed the transfer. She confirmed the transfer to me. She dismissed the complaint. The house on Buckeye Road is mine. I want to say something about the hearing before Judge Adaeze Nwosu and about what the experience of sitting in the Cuyahoga County Common Pleas courtroom was like. I had been in the house for about 3 months by the time the hearing was scheduled, long enough to have started learning the specific character of the rooms and the way the light moved through them in the morning and the evening. The hearing was on a Thursday morning. I sat with Diane at the petitioner's table, and Marcus sat with his attorney at the respondent's table, and we did not make eye contact, and we had not spoken since the filing. Judge Nwosu came in, and she had the measured efficiency of a judge who reviews her materials in advance and who arrives knowing what the legal issues are. She asked Marcus's attorney the question about the legal basis for the argument that a letter could supersede the affidavit. The attorney answered as best he could. Judge Nwosu listened, and then she said she understood the intent argument, and she had considered it, and she found that the statutory framework of Ohio Revised Code 5302.22 was unambiguous about the revocation mechanism. She said the legislature had made a specific policy choice when it enacted the statute, that recorded instruments govern the transfer of real property, and that changes to those instruments require recorded instruments. She said this policy choice protected the reliability of the public record and the certainty of property ownership. She said the affidavit controlled the transfer. She dismissed the complaint. Marcus stood up and left without speaking. I sat for a moment. Diane put her hand on the table next to mine and said, "That is done." I said, "Yes." I said, "That is done." I also want to say something about what the weeks after the ruling were like and about whether Marcus and I had spoken. We had not spoken in the months since he had filed the complaint. The process of a legal dispute with a sibling is its own kind of grief, separate from the grief of the loss that preceded it and layered on top of it. You are grieving a parent and simultaneously in opposition to a sibling over what that parent left, and the two processes are entangled in ways that are difficult to separate. After the ruling, I had been in the house and I had been quiet about it. I had not called Marcus to say anything. He had not called me. About 3 weeks after the ruling, he had sent a short text. It said, "I hope you take care of the house." I had sat with the text for a while. Then I had written back and said, "I will." He had not replied. That was where things were when the spring came and the garden began to emerge, and I had been out in it learning what she had planted. I do not know where things will go with Marcus. I know that the house is mine, and that the record established this, and that the record was what my mother had built and maintained, and that honoring what she built means taking care of the house correctly. That is what I am doing. That is what she would have expected. The house is in the right hands. The record said so. She had made the record say so. 4 years ago, have been in it since the summer after the ruling. The garden my mother had kept for 27 years is still producing because she knew how to plant for the long term, and the things she put in the ground when the house was new are still there and still growing. The neighbors she had known for decades are still on the block. I am learning their names. I am learning the specific facts of their lives that she had always known, the information she had considered worth knowing. I am working on being, for this block and this house, some fraction of what she was. I want to say something before I go. Not about Marcus and not about the attorney fees he paid, about why my mother had created the TOD affidavit in the first place, and about what the specific conversation had been that led her to do it. She had come with me to a presentation at our church about estate planning tools. The presenter had been a local estate attorney who had explained the transfer on death designation as a way to pass your home to your chosen beneficiary without probate and without the cost and delay that probate involves. My mother had listened carefully. She had asked the attorney 2 questions. How long does it take to record, and how do you change it if you change your mind? The attorney had answered both. I want to say something about what I found in the file drawer in the second bedroom when I went through my mother's papers in the weeks after the ruling. The file drawer had the systematic organization of a person who had spent 31 years managing documentation professionally and who had applied those skills at home. The labeled folders were in alphabetical order. The house folder contained the deed from 1996 when she had purchased the property, the subsequent refinancing documents, the annual insurance policy renewals going back 15 years, the property tax receipts, the renovation permits and contractor contracts from the work she had done on the kitchen in 2008 and the bathroom in 2015. And at the back of the folder, the TOD affidavit. The sticky note I described was there, filed, recording date, instrument number, Recorder's office. She had noted every relevant fact about the recording on a small yellow sticky note and had attached it to the front page of her copy. I sat at the desk in the second bedroom and I held the copy of the affidavit, and I thought about the day we had driven to the recorder's office together and about what she had said on the way home. The house is where you grew up. You have been here. I want it to come to you. She had said this in the car on the way home from filing. She had then kept the affidavit in the file folder with the sticky note noting the recording details. She had done everything correctly. The file said so, the recorder said so, both records had kept what she had intended. Both records had delivered it. I also want to say something about the garden notebook and about what it tells me about how she thought about the people who would come after her. The notebook is spiral bound and it has years of entries in her handwriting, some in blue pen and some in black and some in pencil when she had been out in the garden without a pen. Each entry has a date and a note about what had been planted or divided or moved and what the outcome had been. There are seasonal notes about what each part of the garden had looked like in a given year and what she had decided to change for the following year. There is a list at the back of the notebook of the common and Latin names of everything in the garden with the year it was planted and where it came from. Some of the plants had come from neighbors. Some had come from her own divisions of earlier plants. Some had been purchased. The list notes all of this. When I found the notebook, I understood that she had kept it not only for herself, but for whoever would be in the garden after her. She had not known when she started it that the garden would come to me. She had kept the notebook anyway because she was a person who kept the record as a practice, not as a response to a specific, anticipated need. The record was always ready. The notebook, the file drawer, the TOD affidavit, all of it kept correctly and ready to be found. By whoever needed to find it. She had been right to keep it. I use all of it. Mother had been satisfied with both answers. She had said to me on the way home that she was going to do this and that she was going to put my name on it because the house was where I had grown up and because she wanted it to come to me when it was time. She had called the attorney the following week and had had the affidavit prepared. I had gone with her to the notary and to the recorder's office. I had watched her sign it and file it. It had been recorded that day 4 years before she died. Whether she had second thoughts 8 months before she died, I cannot say with certainty. The letter was in her handwriting. It said what it said. But second thoughts expressed in an informal letter are not the legal mechanism Ohio law provides for changing a recorded TOD designation. She had known, when she came home from the notary's office 4 years before she died, that the designation was recorded and that changing it would require filing a new instrument. She had been told this by the attorney who prepared the affidavit. She had asked specifically about how to change it. She had known the answer. If she had wanted to change it in the 8 months after she wrote the letter, she could have. She had not. The affidavit had remained unchanged. The law had given effect to what was in the record. Thank you for staying until the end. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a woman whose half-sister had submitted a forged notarization on a deed transferring their late father's property, and what the Ohio Notary Commission's record showed about whether the notary whose stamp was on the deed had actually been licensed and practicing in that, I want to say something about Cleveland and about the Buckeye Road neighborhood where my mother's house was located and about what the specific character of that neighborhood had been during the 27 years she had been in it. Cleveland is in Cuyahoga County in northeast Ohio on the southern shore of Lake Erie, and it is a city with the specific character of a place that has navigated significant economic transitions over several decades, and that carries in its neighborhoods the evidence of both the difficulty of those transitions and the investment that certain residents have made in remaining and maintaining what they built. The Buckeye Road corridor is on the east side of the city in a neighborhood that has been, over the decades my mother was there, a neighborhood of working families who maintained their houses and their gardens and their relationships with their neighbors with the consistency of people who had decided to stay and who understood that deciding to stay required ongoing investment in the place you had decided to stay in. My mother had been part of this. She had attended the neighborhood association meetings, and she had participated in the block cleanups, and she had been the neighbor who knew which houses were struggling and what kind of help was needed and who had provided it when she could. The neighborhood had known her. When I came to the house to work on it in the weeks after her death, the neighbors had come by to offer condolences and to say specific things about her that showed they had been paying attention to who she was. That is how you know someone has been a real neighbor. The specific things they say when that neighbor is gone. I also want to say something about what Marcus had known about the TOD affidavit and when he had known it. He had not known about it when my mother filed it. She had not told him. She had told me because I had been there and because it was relevant to me as the beneficiary, but she had not made an announcement to Marcus in Denver about her estate planning decisions. This was consistent with the way she handled most personal decisions. They were her decisions, and she made them and documented them and did not seek consensus about them. Marcus had found out about the affidavit after her death when he went looking at the property records, presumably after his attorney had suggested he search the recorder. He had known about it before he called me to tell me about the letter. He had found the letter first, and he had found the affidavit second, and he had called me with the letter without mentioning that he had also found the affidavit. When Diane and I reviewed his attorney's complaint, it was clear that his attorney knew about the affidavit and was arguing that the letter superseded it. The argument was not that the affidavit did not exist. It was that the letter should override it. The argument failed because the law does not allow letters to override recorded instruments. This is a settled principle. His attorney had known the difficulty of the argument before making it. The hearing had confirmed the difficulty was fatal. The instrument controlled. It has always controlled, from the day of recording. The recorder holds the record. The record is public. The record was clear. The neighbors knew her. The block knew her. The recorder held what she had filed. County on that date. It is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if someone in your family claims that a handwritten letter, an informal note, or an unrecorded document changes who receives a property that was covered by a transfer on Death Designation Affidavit, search the county recorder's portal for the affidavit and rate it. Then look for any subsequent recorded instrument that would have revoked or changed the designation. If no subsequent recorded instrument exists, the original designation controls. Ohio Revised Code 5302.22 requires a recorded instrument to revoke or modify a recorded TOD designation. A letter is not a recorded instrument. The recorder's records hold the controlling document. They have always held it. Search the recorder, read the affidavit, look for a revocation. If there is no revocation in the record, the affidavit stands. I want to tell you more about my mother and about what the house on Buckeye Road had been to her and to us. My mother's name was Anita. She had come to Cleveland from Mumbai in 1987 when she was in her late 20s, and she had built a life here with the specific combination of determination and pragmatism of someone who understood that building a life in a new place required both clear vision and willingness to do the work that vision required. She had worked in hospital administration for 31 years at a major medical center on the east side of Cleveland, and she had risen to a position of real authority over that time through the quality of her attention and the reliability of her follow-through. She had bought the house on Buckeye Road in 1996 when the neighborhood was the kind of neighborhood that required belief in what it could become, and she had believed in it, and it had become what she had believed it could. The house was a 2-story frame house on the south side of Buckeye Road with a garden on the east side of the lot that she had developed over 27 years into something that her neighbors had been coming to admire for at least 15 of those years. She had known what she was doing in the garden the way she knew what she was doing in most things, which is to say she had learned the principles and applied them consistently and had adjusted what needed adjusting. I want to say something about my mother and about the quality of her attention to things she considered important. She had worked in hospital administration for 31 years, and she had the professional habits of a person who understood documentation and who knew that what is not documented does not reliably happen. She had brought this to her personal affairs with the same consistency she had brought to her professional ones. She had kept a file for the house, the original deed, the insurance policies, the tax records, the renovation permits, the mortgage payoff documentation, all of it in labeled folders in the file drawer in the second bedroom. The TOD affidavit had been in the file with a sticky note on it that said filed and the recording date and the instrument number. She had noted the instrument number. I had found this when I went through the file after she died. The file was in order. Everything was labeled. Everything was where it could be found. She had done this with the specific intention of a person who understood that organized records are a form of care for the people who will need to find things after you are gone. She had made sure the affidavit was findable. It was findable. I found it in the file drawer and in the recorder's portal on the same evening. Both records said the same thing. The file confirmed the portal confirmed the file. She had left the documentation in 2 places. Both were in order. She had always worked this way. She always had. I also want to say something about the hospital where my mother had worked and about what her 31 years there had given her. She had started as an administrative assistant in the billing department and had risen over the decades to a senior administrative role overseeing several departments. Her rise had been the product of the specific combination of intelligence, reliability, and interpersonal skill that administrative leadership requires, and of the willingness to do the work that needed doing without waiting for it to be formally assigned. She had been, at that hospital and in the community around it, a person of real standing, someone whose judgment was sought and whose decisions were reliable, and who had built a record of 31 years of work that spoke for itself. When she retired, the department had held a party that people still talked about 5 years later because the number of people who wanted to be there had filled a room that had not been designed to hold them all. She had sat in the center of it with the particular composure of a person who is not surprised by the evidence that people value them, but who is moved by it anyway. She had brought to her personal affairs what she had built in her professional ones, the understanding that what you intend must be documented correctly if it is to be relied upon. The TOD affidavit was this principle applied to the most significant asset she had. She had applied it correctly. The record had held it. The law honored it. And she had been right to trust that the documented intention would be honored. It had been honored. The affidavit said what she had intended. The record said what the affidavit said. The law gave effect to the record. She had been right to trust this. She had always been right to trust documentation. 31 years of professional experience had confirmed it. 4 years of the affidavit in the recorder had confirmed it again. The documentation had worked. It always works when you do it correctly. She had done it correctly. The house is mine. The record says so. She made the record say so and had been patient with the things that required patience. My mother had raised Marcus and me in that house. Marcus is 3 years older than I am, and he had moved out when he was 22 and had lived in several cities since and had been in Denver for the last 8 years. I had stayed in Cleveland. I had lived in an apartment in the Tremont neighborhood for 7 years, but I had been in my mother's house twice a week for dinner every week of those 7 years, and I had been the one who drove her to appointments and who was there when things needed to be done and who had been, in the practical geographic sense, the child who was present. My mother had noticed this. She had told me she noticed it. She had said she was grateful for it and that she did not consider it an obligation on my part, but a choice that she valued and that she wanted to acknowledge. The TOD affidavit had been one form of acknowledgement. She had said this to me directly on the drive home from the recorder's office the day she filed it. She had said, "The house is where you grew up and you have been here and I want it to come to you." I had said, "Thank you." She had said, "That is what it is for." I want to describe what the Cuyahoga County Recorder's portal shows when you search a property and find a transfer on Death Designation Affidavit. The portal allows you to search by property owner name or by parcel number, and it returns a chronological list of all recorded instruments for the property. When I searched my mother's name that evening after Marcus called, the instruments appeared in reverse chronological order, the most recent entries first. The TOD affidavit appeared near the top of the list because it had been filed 4 years ago, and there were very few instruments recorded after it. I clicked on the entry. The affidavit document appeared. The first page showed the property description and my mother's name as transferor, and my name as the sole designated beneficiary. The effective date was the date of the transferor's death. The document had been executed before a notary, and the notary's seal was visible, and the document had been stamped by the recorder's office with the date and instrument number at recording. It was in the record. It had been in the record for 4 years. It said what it said. I want to end with something about the spring. I moved into the house in July, about 4 months after my mother died. By the time the ruling came, I had been in it for 3 months and had started learning what it meant to maintain a house at the level she had maintained it. The garden came up in April the following spring. I had spent the fall trying to understand what she had planted and where and what it needed, and the spring revealed the answer to several questions I had not been able to answer from the dormant beds. The things she had put in the ground came back in the order she had arranged them. Early bulbs first, then the perennials in their sequence, then the later bloomers that carried the garden into October. I had watched the sequence unfold over several months, and I had learned the names with help from the neighbors and from a notebook she had kept with the planting dates and the care requirements written in her handwriting. She had kept a garden notebook. Of course she had kept a garden notebook. It was in the second bedroom next to the file drawer with the house documents. She had documented the garden the same way she had documented everything else, in writing, in a place where it could be found by someone who needed to find it. I used the notebook. I followed the schedule. The garden comes back. The affidavit is in the recorder's index. The house is mine. She made it so, correctly, 4 years before she died. The record delivered it. It always does, when you do it right. I want to say one more thing about the TOD affidavit as an estate planning tool and about why I think more people should know it exists. Ohio has had this instrument available since 2000, and it is underused because most people do not know about it. It costs relatively little to prepare compared to more complex estate planning instruments. It avoids probate for the property it covers. It is revocable and changeable during the owner's lifetime. It creates a public record of the owner's intention that is accessible to anyone. It can name one beneficiary or multiple beneficiaries. It can be combined with a will that governs the rest of the estate. My mother had learned about it at a church presentation and had acted on the information within a week. She had had the affidavit prepared by an attorney who explained it to her clearly and answered her questions. She had filed it with the recorder. She had kept the copy in her file drawer. The whole process had taken about 2 weeks from the presentation to the recording. The instrument had been in the record for 4 years when she died. It had protected the most significant asset she had built and delivered it as she intended. 2 weeks of effort, 4 years of protection, a clear transfer at the end. She had done this correctly. She had trusted the record. She had trusted the record. The record had kept her trust. It always does. A screenshot, and I sent it to Diane the next morning. I want to say something about what a notarization means in the context of a TOD affidavit and about why the formal execution requirements for this instrument exist. Ohio requires that a transfer on death designation affidavit be executed before a notary public. The notarization requirement serves multiple purposes. It confirms that the person signing is who they say they are. It witnesses the signing event, and it provides a dated record of when the instrument was executed. The notary's seal on my mother's affidavit confirmed that she had appeared before a notary, that the notary had verified her identity, and that she had signed the document on the date shown. This is the opposite of a handwritten letter, which has none of these formal verification mechanisms. The letter Marcus had found was in my mother's handwriting and was signed with her name, but it had not been executed before a notary, it had not been filed with any government office, it had no instrument number, and it had no official record of being created. The affidavit had all of these things. The affidavit was the formal instrument. The letter was an informal expression. Ohio law draws this distinction sharply and for good reasons. I want to explain something more about why Ohio's recording requirement for TOD revocations exists and about the policy behind it. When you record a transfer on Death Designation Affidavit, you create a public record of your intention. Anyone who searches the recorder's portal can find it. The beneficiary knows about it. Future creditors, buyers, or family members can find it. The public record nature of the designation is part of what makes it reliable and what makes it useful as an estate planning tool. If informal, unrecorded documents like letters could supersede a recorded designation, the reliability of the public record would be destroyed. Every recorded TOD designation would be potentially overridden by a private letter that no one had seen, and that might or might not be genuine. The certainty that makes the TOD instrument useful as an estate planning tool depends on the rule that only recorded instruments can change recorded instruments. My mother had known this rule because she had asked about it specifically. She had asked how to change it if she changed her mind, and she had been told, "You file a new affidavit or a revocation with the recorder." She had not filed either. The recorded designation was the last recorded statement of her intention for this property. I also want to say something about the experience of being at the county recorder's office the day my mother filed the affidavit. We had driven to the courthouse in downtown Cleveland on a Tuesday morning. The recorder's office was on one of the upper floors of the courthouse building, and it had the specific functional quality of a government office that processes documents all day and that has organized itself for efficiency. There was a counter, there were forms, there was a brief wait. My mother had her documents in order, which was the way she always had her documents, in order. The clerk reviewed the affidavit, verified that it met the formal requirements, accepted the filing fee, and stamped the affidavit with the recording date and the instrument number. The stamp was the confirmation that the instrument was now in the public record. My mother had looked at the stamp for a moment. Then she had put her copy in her purse with the specific careful movement of someone putting a document in a place where it would be kept. She had said good. She had said that is done. We had driven home. I had not thought about it again until Marcus called. I want to describe what the Affidavit of Confirmation looks like and what the process of completing the transfer required. When the owner of a property subject to a transfer on death designation dies, the designated beneficiary completes the transfer by recording 2 documents with the county recorder, an Affidavit of Confirmation and a certified copy of the owner's death certificate. The Affidavit of Confirmation is a sworn statement by the beneficiary confirming that the conditions for the transfer have been met. The owner has died. The recording of the TOD affidavit and the death certificate completes the transfer. Diane prepared the affidavit. I reviewed it. I signed it before a notary. I filed it along with the certified death certificate. The recorder processed both. There was no court proceeding for this step. There was no probate filing. The property transferred by operation of law because the instrument that governed the transfer had been in the public record for 4 years and its conditions had been met. This is the efficiency that my mother had sought when she filed the TOD affidavit. It had worked as intended. I also want to say something about Marcus and about what I believe he had understood about the situation. I do not think Marcus had invented the letter. I believe my mother had written it and that it had reflected her thinking at a particular moment. I also believe that my mother had not followed through on changing the affidavit, and that this was either because she had decided not to change it, because she had not gotten around to it, or because she had not fully understood that the letter alone would not accomplish a change. These are different things, and I do not know which is true. What I know is that the legal effect of the situation was determined by what was and was not in the recorder's record, and that what was in the record was the original affidavit naming me, and that there was nothing in the record changing it. The law gave effect to the record. That is what the law does. It gives effect to what people formally documented and recorded because those are the documents that can be found and verified and relied upon, And because the reliability of those documents is what makes property ownership stable and predictable. The letter was real, but it was not the record. The record was the affidavit. The affidavit controlled. There is one more thing I want to say, and it is about the garden. My mother had planted the garden in layers and with attention to what bloomed in sequence, so that from April through October, something was always in color on that east side of the lot. She had known the names of everything in it, and had known when each thing needed attention and what kind of attention it needed. I had watched her work in it for 27 years, and I had absorbed some of what she knew, but not all of it. And the first spring in the house, I had been out there with a gardening book trying to identify some of what was coming up and understand what it needed. The neighbors had helped. They had known her garden from decades of looking at it, and they had been generous with what they knew about it. I had learned the names of the plants and the neighbors at the same time, which felt like the right way to learn both. She had built a garden and a set of relationships on that block, and the two things were woven together, and learning one meant learning the other. I am still learning. The garden comes back every spring. The things she planted are patient. The record she filed is in the recorder's index. The house is mine. The learning continues.